Mr. Bailey, your rebuttal.
Thank you. Ladies and gentlemen, this case is about these defendants. Defendants who acted like bullies on a playground. Defendants who had, two of which had the motive and the reason to attack Mr. Hood. Now to start off, ladies and gentlemen, we've heard a little bit about the justice system and fairness. We've heard about the justice system in this case getting to this point. The United States justice system is an incredible justice system, and I think it's worth a few minutes to take some time to go over that. There's different justice systems in this world. Justice systems where judges decide everything. Justice systems where the government makes all the decisions and is used for political purposes. There's justice systems that effectively have no justice, they're actually not justice systems at all, because victims never receive rehabilitation or justice. Our system uses a jury of its peers. Ladies and gentlemen, that's you. It's members of this community that decide this case. It's not attorneys, it's not judges, it's members of it's peers, members of our community. And when you sat down, all of you took an oath in this case to judge this case based on facts. Not based on speculation of what might be going on behind the scenes, but based on the evidence that you have received in court. You all can use your common sense. That's what our justice system tells you to use. Your common sense. When individuals take the stand and testify, when evidence is presented in front of you, attorneys try to give their perspective on it, but at the end of the day, it's your job to use your common sense, to apply the facts that you have received, not guess about facts that are out there that you might not know about, or that might be different if you heard it a different way, but the facts that you have in evidence, and to apply it to the laws that govern our community, that we all have some role in creating and administering. This is a case that's not about people, it's not about attorneys, it's not about cops, it's about people. It's about people just like you, and that's why people just like you decide this case. It's very important. And I would argue that this justice system has succeeded because this case is here in front of you today. This system worked exactly the way it should. Now, we've heard a lot about jury instructions, and I'm not going to go over a lot. This is the 5th time you've heard someone close. I recognize that and I respect that. But we haven't heard about separate counts and separate defendants. That'll be on page 6, and you can go over the last 4 paragraphs. I'm not going to put it up on the screen, but essentially it tells you to take the evidence that you received and to apply it to each individual. You don't have to apply all the evidence to one person and say one person's guilty, that means they're all guilty. It doesn't work like that. The evidence and the rules apply to each person individually. You also heard defense say that if you were to judge right now, when we first started this case up, there was no evidence that was presented to you. You must find the defendant not guilty. And that's absolutely correct. And that's how our justice system works. I don't need to tell you that. But what we do know is that you also do not have to overcome all doubt, every doubt. There's a burden that you have in your instructions, and it's reasonable doubt. Reasonable doubt means reasonable doubt, and we often get questions, well, can you please put a percentage on what reasonable doubt is? Do I have to be 90% certain, 80% certain? What is the percentage? And like attorneys usually do, we don't give you great answers on that. But if you look, and this will be on page 3, paragraph 3, when you're back in deliberations, reasonable doubt means that you're left firmly convinced of the defendant's guilt. So if the case state has proven its case beyond a reasonable doubt, what that means is you're left firmly convinced of the defendant's guilt. It's not speculative doubt or evidence that you, again, might think is out there that you don't have. It's based on the evidence that you have in determining whether you're firmly convinced of these defendants' guilt. There also is an instruction about credibility. And credibility is something that you can use your common sense with. And to give you a an example of that, y'all understand that you can have, we've had the defense attorneys say that these people aren't credible at all. There's no reason to believe anything, and that this case is already over. Y'all understand that people that you don't believe can actually be credible based on the corroborating evidence that you have. It makes sense, but it's something that we don't always think about. I use the brother-in-law example who tells whoppers. And he tells you about how he's been to the moon or sailed around the world. And every time you see that individual, they have a new story for you that you just don't believe. But let's say that brother-in-law comes into your house and he tells you, I just saw a pink elephant walking down the road. Now, the first thing you say is, look, I mean, you've been on the moon, you've sailed around the world, there's not a pink elephant this morning. But he tells you, no, there really is, you gotta come out and see it. So you walk out, there's no pink elephant outside. But what do you see? You see some droplets of pink paint on the ground. Okay. You see some big, round-looking footprints. Who knows what that's from? You then hear neighbors that said they heard stomping on the ground around them. All right? You hear another neighbor that says they heard a wail and it sounded like an animal wail. Okay. Now maybe this person that's never credible to you before, based on the corroborating evidence that you have in this case, is credible now. And then you go home, you turn on the news, and there's a pink elephant that escaped from the zoo. Was painted pink, and it has exactly like your brother-in-law said. That's how we use corroborating evidence. That's a simple example of explaining the importance of looking at all the facts in this case. Because what do we have here in this case? We have a jigsaw puzzle. Each piece has its own significance. Each piece has its own importance. And you may see that piece or hear that piece early on and say, well, how does that really matter? Why do we care about that? Just kind of filler and wasting our time, or let's move along. But each piece needs to be viewed with the other pieces of that jigsaw puzzle. Because you have a piece and you don't know what it is, but then you have 5 or 6 other pieces, and all of a sudden you start to see, well, what I know is based on this one piece, I have no idea what it is, but with these 6, 7, 8 other pieces, I have a picture of a cat. So that's how we look at this case. We look at this case, each fact individually, and we see what we know collectively in the case, and we put it together. So I'm not going to go through each fact that you have. I know you've been here for a long time. But I'm going to hit on a few people, such as Mr. Ruiz and Mr. Rivera. You didn't hear a whole lot about Mr. Ruiz and Mr. Rivera from defense. That's because they said they saw 6, 7, 8, 9 guys running after a victim at the end of the street. They said they were minding their own business. Now you heard the defendant say, well, they weren't really paying attention, so they didn't get a good look. But then they say, but they'll tell you that he wasn't 6'9" or 6'10". So they want you to have it both ways with their credibility. But what do we hear? We saw Mr. Ruiz say that the defense attorney and defendant looked about the same height from where he was. We also heard from Mr. Rivera that these guys were bent over, running, chasing, and he couldn't get a great description. That's a fact that we apply to other facts in this case, such as Joe Murray. What do we know that Joe Murray says? Attorneys, when we summarize facts, and just humans in general, we don't always say exactly what was said on the stand. And that's why it's so important to listen to the witnesses that were in front of you. Joe Murray said, I wasn't really paying attention to the area that Ms. Sherrod said the first fight was. What I was coming back from dumping some garbage and I saw a group of people running away. They just happened to be running away in the area that Ms. Sherrod said the fight was, but we'll get to that. We also know that Mr. Murray said that Eric was severely injured, was crawling to the car when he went down to the end to help them out. So we know Eric is hurt. And you're saying, well, why does that matter? Well, it matters because there was discussion about getting him to an ambulance at the hospital, and trying to get him help. We heard Mr. Halal, and Mr. Halal is another individual they want to have it both ways with. Mr. Halal said he came out after Ms. Sherrod already came in, screaming that there was a fight. He came out with Mr. Miller. He saw One of the Morris brothers and another Morris brother running down there. He doesn't get there for about 30 to 35 seconds. And this is where he says that defense didn't bring up. He said that Markeith stood there, got in front of him, said there's nothing to see here. That matters. Whether you apply that for accomplice liability or not, that matters because that shows what he's thinking. That shows his intent. He doesn't want anyone to go further because he knows what's going on down there. You heard Mr. Miller say when he ran out with Mr. Halal and he shouted, "Hey Morris, what's going on?" Markeith took off down to where the fight was. And how do we know that matters? Because by the time they get down there, we know that Ruiz and Mr. Rivera said they saw a group of individuals going down there and a large group of individuals fighting. By the time they get down there, they say that they can see Marcus stand. Mr. Hall says he saw Marcus standing with about 7 to 10 feet away, and he saw he saw one other person in the fight, and then it was dark, and he couldn't see what was going on. Markeith has already given him the heads up about people are coming down. That's why he's a lookout. He is. And when we talk about people that are in that area, you hear testimony about how there's only a few people walking back, but we know a group of people went down there for it. Because they've already split, because they got the heads up. This is why it's important to look at each piece of evidence individually and apply it. And again, I'm obviously making my arguments. That's what each side does, that's what each attorney does, but rely on the facts that you got from the stand. Look at your notes. We're talking next about Ms. Sherrod, and we're talking about Ms. Sherrod's credibility. And it's actually something that you should consider. You got those text messages. They should be considered. But remember, Ms. Sherrod admitted that on direct examination. She said, yep, I text about money. I put laugh out loud because I wasn't really serious about it, but I absolutely did. She talked about how she had a crush on Eric. She really liked Eric, and she was interested in Eric. What else do we know? We know she's had a boyfriend for the past 2 years. And we know she's never filed a civil suit against these individuals. She never did. She doesn't have one pending. We talk about, again, going back to corroborative evidence. And they said there was none. Really? We just went over that. We just talked about the pieces of that jigsaw puzzle that you can use to look at her credibility. Whether you believe her or not, you can look at other pieces of evidence in this case, and she is believable. You heard statements about 37 basketball players being in the evidence, and you right now, they say they didn't see anything going on there. You have no idea, because not one of those individuals came in here to testify. And guess what? Defense, just like the state, has subpoena power. The defense, just like the state, could bring in a witness if they wanted a witness. So that's why it's so important not to speculate about what is out there, but to decide this case based on the facts that you have in front of you. We know that she runs in and she screams for help. She does this after she already saw the initial hit to the back of Mr. Hood's head. He's taken off running, and she says that she saw that fight in the grass area. And we'll talk about the map in a little bit. But she said that this occurred when Mr. Halal and Mr. Miller aren't out there yet. She goes back in there and screams for help. When they come out, it just so happens that Markeith is in the area where she said the attack occurred. And look at the map. We're going to go over that. But take the time to look at that map. We know that she also yelled out that the Morris brothers did this while Mr. Hood's trying to get into her vehicle to take him to the hospital. So the defense wants you to believe that she's already had this plan. She hasn't even had a chance to know what's going on. She told you she never realized that those guys were there. And now she's saying that the Morris brothers did that. So they want you to believe that there was this conspiracy to create the Morris brothers in this case. She's yelling it out at the scene. She's asking how to get to the hospital. We then hear on a 911 call, she said she had to pull over because she was frantic to try to figure out where the hospital was. And you listen to that, and you'll get to listen to it again if you choose. But she says the Phoenix Suns players did this with about 10 guys. We also talked about her ID of Mr. Bowman and her picking him out of a photo lineup. She picked him out of a photo lineup when Mr. Hood couldn't. Okay, so if there's a conspiracy about that, then how is she able to pick someone else out? You say she had a photo of him. Why didn't she pick out Mr. Melendez then? She has a photo of all of them. Would have been easy enough. She got a photo lineup with Mr. Melendez in it. I've seen my photo, I'm going to pick him out. She didn't do it because she didn't recognize him in that photo. She recognized Mr. Bowman. That's why she picked him out. So the fact that she couldn't ID another individual provides credibility to her statement as to Mr. Bowman being. Looking at the map, there's been a lot about the map, what the map depicts, the old map versus the new map. Ms. Sherrod was asked with the map that she was giving to show what happened. Take the time to look at those maps. They're not that different. Everything that she says happened in that attack, if you look in the field, you'll see it says kick, jump, in the field. If you look at the new map, there's a field right there. This isn't a map where all of a sudden we have the field's a parking lot or a pool or another gym. This is a parking lot that got moved up. Everything that she says happened could absolutely have happened on both maps. She did the best she could with the map that was given to her by the detective. And those maps are not that different. So look at those maps if you have concerns. And also look at the map on her specificity on where things happen and where things occur. Again, we talked about how this was planned by Ms. Sherrod and Mr. Hood. However, even defendants stated that their stories don't match up. Well, why? And their stories not matching up is a problem for them. No, it's not. That's called human nature. Everyone has a different perspective on what occurred, especially when one of those individuals, as we'll discuss, took a blow to the head pretty early on in this. If they're going to conspire to implicate people, then they would get their stories right. Makes sense. Their stories are different because of the different perspectives that they have and because they didn't talk to each other about what was happening. So we turn to Mr. Hood, and we know, as I said, that Mr. Hood took a blow to the back of his head as soon as he steps out that gym door. Mr. Kane is sitting in front of him, says, you know what's good, you know what it is, and he gets hit in the back of the head. And from that point forward, Mr. Hood said he was running for his life. Mr. Hood didn't say there was an attack where Mr. Sherrod said, but we also know Mr. Hood got beat up pretty bad. We know right from the beginning, Mr. Hood got a hit in the head, and when you look at the photos of Mr. Hood, you can see a gash in the head. Think of the force it takes to make a gash in the head of someone. Think of the beating that he took at the end of that street. Okay, it makes sense. Use your common sense if you're in that situation. How much detail do you think you're going to remember of what's going on? Where are you going to be able to place everybody? Ms. Sherrod walked out. She was the one that wasn't attacked. She was able to observe what happened. You've heard about Mr. Hickerson, and Mr. Hickerson should actually absolutely be considered. It's always interesting when defendants want to implicate people that aren't in the courtroom. To me, that seems like a contradiction, but Mr. Hickerson should be considered. But you also know that each of those individuals, including Mr. Hood, said that Mr. Hickerson did not have any effect on his testimony. Mr. Miller said that, Mr. Halal said that, Mr. Hood said that. What Mr. Hickerson did or not do, because we don't even know if that's Mr. Hickerson, we're just being told that there was a phone call from someone identifying themselves as Mr. Hickerson. What he did or did not do in this case, the witnesses on the stand said did not affect him. Consider the credibility. I'm not telling you not to do that. Consider how that affects the case. But also consider that we have recorded conversations immediately after this attack from Ms. Sherrod and Mr. Hood. Consider the money aspect of it. I'm not telling you not to. It's something that should be considered. But also consider that the fact that he was beat severely by these individuals and he wants them to pay. And in our justice system, we don't force people to do time, hard labor, work on their house. We compensate people by having them pay for what they've done. And that's just a normal thing in our system. Ladies and gentlemen, consider what Eric said in light of everything that you have. Consider what Eric said in light of the attack that he's taken. Consider his credibility. But again, think about what Ms. Sherrod said. Look at what corroborates her testimony. Defense said that cases can ruin defendants' lives. Attacks ruin victims' lives. What we don't do is decide this case based on sympathy or emotional feeling. We decide it based on facts and evidence. Let's turn to Cain and Melendez. And the fascinating question that was asked, and every question that's asked by a juror is fascinating because we don't think like our peers. That's why you get to decide this case and not us. You think about things we don't think about. But Mr. Cain and Mr. Melendez were the fall guys in this. We've heard that they're not athletes. We've heard how people said they're not important. We heard from Mr. Hood himself called Mr. Cain a peon. And let's talk about that for a second. No one is a peon. Every person in this court matters. Everyone in this court has importance. It doesn't matter how much money you have, how much education you have. It doesn't matter your role in society. Everyone here as an individual is important. So that was not right. But let's think about why he might have said that. Defense tried to kick in a motive, or have you speculated on some motive about some tension between the two because he was so upset when he asked Mr. Cain that question, or asked Mr. Hood that question about Mr. Cain that he called him a peon. What do we know? 2.5 years later, after this attack, we know that Mr. Hood was, in fact, assaulted by Mr. Cain. So do you think that Mr. Hood might be a little bit upset with him because he was beat up by him? That's a natural human emotion. All right? Mr. Hood said he had no involvement with that individual whatsoever before. Was basically a hang around, didn't think anything of it. He's upset with them afterwards. He's upset with them because Mr. Cain was involved in an attack on him. They tried to backdoor a motive because a motive is important in this case. You don't have a motive except for the text messages between Mr. Hood and the Morris's mom. And when the Morrises were asked by law enforcement about Mr. Hood, never heard of him. Not even that he wasn't there, never heard of him. The motive in this case, and you have an instruction on motive, the motive in this case is important because it explains why this happened. Turning to Barber Joe and Miss Howell. The text that you have of an individual's head is just that. It's a text of someone's head. He said that it was a haircut that he's done prior to that. You're going to have to go off his word because that's the only thing we have about that being a haircut. What we do know is the text of his head. Now the text message that we have between Mr. Bowman and Mr. Joe has no indicia of reliability. There's not even reference to a haircut. There's not reference to people. We don't even have a picture of the phone it came off. And you heard about computer-generated text messaging and faking fake text messages. And you heard that question, and it's absolutely important to keep in mind that there's not any evidence that Mr. Bowman used that. But it's important to consider that when you're trying to determine the reliability of the text message that he presented in court that day. Because he didn't present it back when this investigation was going on. And there was a question, and again, all questions are good. There was a question about whose job is it to get text messages? It's a great question. Because we know that police got Mr. Hood's text message. We know that the police got Ms. Sherrod's text messages and photos. So whose job is that? Well, you also heard Detective Santos say that he had no information that there might be text messages on the cell phone. He got a call from an attorney representing Mr. Bowman that said, there's something that we want you to check out or might have happened at the mall, and he did follow up there and he couldn't find anything. But we have nothing for Mr. Santos to go and investigate on that. And the example I use is if We believe that a body is buried in the backyard in the neighborhood. We don't go and dig up holes in everyone's neighborhood. We look for evidence to support a reason to go there. We find information, a reason for us to do that. Ask yourselves, if you found out the detectives went in and flipped over every mattress, went through every personal photo for these defendants and suspects in this case, whether you'd be upset with that. You probably would, because even suspects, even defendants have some right to privacy. He needs the information to be able to do the follow-up. He never got that. And Mr. Bowman says it was vital. He told you that. It was vital to my draft for me to try to clear my name. If these text messages were there, that was the first thing he would turn over to police. We also heard about Mr. Bowman and the bandana. It's interesting, when Mr. Lackey was pointing out, trying to use this picture to see what people look like, it's interesting to see that this individual looks like he has something like a bandana. But the reality is this picture doesn't show us a lot of detail in general. You're going to be able to look at this picture, like Mr. Lackey said, and try to determine who or what is in that photo, but there's not a lot of detail in that photo. Mr. Bowman was also adamant that he never wore a bandana, didn't own a bandana. You heard about him. He was adamant that this text message was based on his word, and that's all he had was his word, and that he was being truthful about that. But then there is a photo of him with the bandana, and it's only from a few months ago when you look at the date. That's something that's hard to forget about. And it just happens to be worn in the same way that the attacker, that Ms. Sherrod said, wore the bandana. The purpose of that is to use it for the defendant's credibility. Consider that in light of what he stated. I'm done. I know you're ready for this case. This is a serious case. And we know that Mr. Hood was undeniably a victim of a violent assault. Your decision must be based on the facts applied to the law that you have. It's not based on what I argue. It's not based on what defense counsel argued, because none of us were there. The witnesses that took the stand were there. The witnesses that gave you that evidence were there. That's the information that you use to decide this case. You heard some comments about this case as being laughable or insulting. Those are inflammatory words used to get your emotions up. This case is decided on facts. This is a great justice system. It protects people from government overreach. It protects victims of assault and helps them get rehabilitated. It applies to whether you're white or black, weak or strong, male or female, sympathetic or unsympathetic. There was a comment about attorneys dreading this point to getting this to you because we don't have control. The state embraces that. That's how this system works. This case deserves to be in front of you. This case deserves your consideration, whatever outcome you decide. Ladies and gentlemen, this case is about these defendants. Defendants who acted like high school bullies on a playground. Defendants who had Mr. Morris, Markeith and Mr. Marcus Morris, who had a reason, text messages, had a motive for this. The evidence in this case, looking at all the corroborative facts, leaves you firmly confident of these defendants' guilt. Thank you very much for your time.
Thank you.